Mr. Cervantes is 28 years old. This case represents his first contact with the criminal justice system and his first conviction of any kind. He is employed as a Detroit police officer serving the community.
This case is one you won't want to miss. A Detroit police officer, yes, an actual cop, sits before Judge Bryant, facing charges for operating while visibly impaired, all stemming from an accident that could have ended lives. Now here's the kicker. This is his very first offense, yet it's packed with enough twists to keep your jaw on the floor. We're about to see how the court handles law enforcement breaking the law and the consequences for someone who's supposed to uphold it. You'll hear a heartfelt apology, a disappointed judge, and one chilling line that sticks with you. You tested positive for alcohol on bond. Is this a one-time lapse or a deeper problem? And should officers be held to a higher standard? Or is justice blind even for the badge? Strap in, because Judge Bryant is not pulling punches today. Let us know in the comments, should he get a second chance or serve time like anyone else?
All right, then this is case number 2445300601, the people of the state of Michigan versus Marcos Alexander Cervantes. The defendant is charged with one count of operating while visibly impaired, and today is the date set.
So here we go, Mr. Cervantes is officially charged. This isn't just a ticket, it's a criminal charge for operating while visibly impaired, which, in Michigan, doesn't even require a specific BAC. All it takes is the officer's behavior to cross a line. This moment sets the legal tone. It's not about how drunk you were, it's about how impaired you appeared. That gives law enforcement a lot of discretion, and as irony would have it, that same discretion is now turned back on a fellow cop. Do you think that's fair? Or does this leave too much room for bias in how these charges are filed?
For sentencing, appearances, please.
Good morning, Your Honor. Max Beisel, P77513 on behalf of the people.
Good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of Marcos Cervantes, who's present via Zoom this morning.
Mr. Cervantes, state your full name for me.
Good morning, Your Honor. Marcos Alexander Cervantes.
All right, today is the date set for sentencing. Well, yeah. Okay, today is the date set for sentencing, and I have had an opportunity to review the pre-sentence report with respect to the same. Are there any additions, deletions, or corrections on behalf of the people?
No, Your Honor.
Give me 1 second. Why doesn't it? Okay. And on behalf of the defense, any additions, deletions, or corrections?
No, Your Honor.
All right. With respect to sentencing, do the people wish to be heard as to sentencing?
No, Your Honor.
All right. Mr. Forrest, do you wish to be heard?
Yes, Judge. Mr. Cervantes is 28 years old. This case represents his first contact with the criminal justice system and his first conviction of any kind. He is employed as a Detroit police officer serving the community. He understands, and I've, throughout this process, it's been quite evident to me that this has had a big impact on him, and he's committed to making sure that nothing like this happens again. And I know that he wished to address the court regarding this. So I hope that you would take all that into account when imposing sentence, Your Honor.
All right. Mr. Cervantes, would you like to address the court?
Yes, Your Honor.
You may.
This is where it gets real. Cervantes is emotional. He owns his mistake, acknowledges the danger he caused, and openly reflects on nearly ruining lives. This isn't your typical defiant defendant. This is a man who wears a badge and knows he failed. But here's what the court cares about. Remorse doesn't erase risk. And DUI cases involving law enforcement aren't just personal failures. They're public safety issues. So let me ask you, is owning up enough, or should accountability include serious penalties, regardless of apologies?
I'd just like to take the time and first, I'm really grateful I'm still here today. and really grateful that those people that were also involved in that incident are still here today. I tell you, I've taken a lot of time to reflect on this situation, and I don't want anything like this to ever happen again. This is not, I don't want this one incident to define me as a person and my character. I don't take this situation lightly, and I'm willing to do whatever it takes to get back on the right path and make sure that an incident like this never happens again. I'm truly grateful that everybody walked away okay. It's my biggest takeaway from this. And at the end of the day, I put their lives in danger, my life's in danger, and I regret that decision every day.
All right, okay, the court is ready to impose sentence. I appreciate those words. Of course, as a law enforcement officer, you are aware of how dangerous that is and was, and, but, you know, I often quote, one of my favorite lawyers who I've never met, just of course know of his work, and then they made a movie about him, but Bryant Stevenson, who says we're better than the worst thing we've ever done. And so we make bad choices.
Judge Bryant drops a powerful quote here. We're better than the worst thing we've ever done. But don't get it twisted. This is not leniency. This is legal grace with a warning. What hits hard is the judge's disappointment, especially after learning Cervantes tested positive for alcohol while out on bond. That's a direct violation. And while she's not hammering him now, she makes it crystal clear, one more mistake and you're off to sobriety court. This is a rare glimpse into judicial discretion, where mercy and authority intersect. Would you give him another chance after violating his bond? Or was that his last strike?
I don't consider some of them mistakes. They're bad choices. Now, Mr. Cervantes, I was disappointed when I read your pre-sentence report. I was disappointed that you tested positive for alcohol. I was disappointed in that. Your bond condition was that you were not supposed to be drinking. So in essence, you violated your bond conditions. I am ready to impose sentence. I'm not going to necessarily penalize you for that violation, but also understand that if it appears that your problem is serious, I won't hesitate to send you to sobriety court, which is more intensive, which is gonna start your probation over. At whatever point I would put you in sobriety court, now you have to do 14 months for sobriety court. That's their program. So I was disappointed that you tested positive for alcohol. But I'm going to follow the recommendation of probation at this time and sentence you to probation for 12 months. That will place us with a final review date of January the 2nd, 2026. A midway review date where you would be eligible to be discharged early from probation if you have completed the terms and conditions of the probation would be July. And I'm going to set that for July let's see. I'm going to set it for Tuesday, July the 15th. That review will be at 10 a.m. It will be on Zoom. If you have completed the terms and conditions of the probation.
12 months probation. That's the sentence. But here's the real twist. There's a possible early out. July 15th becomes the halfway review, and if Cervantes plays it perfectly, he walks early. But the judge makes one thing brutally clear. This is not a free ride. One slip, and that clock resets with added programs, costs, and possibly even jail. And here's something that stands out. Officers like Cervantes often get these conditional breaks, but does that make the system fair or broken? Drop a comment. Should early release even be on the table for someone who already broke bond?
that I'm going to set, then you will be eligible to be discharged early from probation. If you have not completed the terms and conditions of the probation at that first review, there's no penalty to that unless I penalize you for something else that, or send you to drug court, but sobriety court. But if you don't complete the terms and conditions, it's a year-long probation. So there won't be any penalty for not finishing early. You just won't get the benefit of that. The conditions of your probation, of course, are as follows. You shall not violate any criminal law of any governmental unit. That means no new cases. You cannot leave the state of Michigan without consent of the court. You must notify probation immediately of any change of your address, phone number, or employment status. And you will pay the following fines, costs, and fees. Oh, and you must report to probation on a monthly basis if I didn't say that. You will pay the mandatory cost of $210, a $400 fine. Counsel, Mr. Beisel, I noticed in the report that probation had not been able to reach anyone with respect to restitution. Are the people requesting any restitution at this time?
Not at this time, Your Honor.
All right. I'm going to set restitution at 0 and note that if the complaining, the victims reach out, that I'm only gonna give 2 months for them to contact someone, because if Mr. Cervantes is trying to get off probation early, it's not fair for me to leave something open. So I'm going to set it at 0 and indicate that a restitution hearing must be requested by, this is January, February. Really, I'm going to say in 30 days, really. But restitution hearing must be requested, I'm going to say by February 7th.
Thank you, Judge.
Let's talk money. Because this isn't just about freedom. This man's walking away with a $1,280 price tag if he completes probation, or $1,025 if he gets out early. It's a financial balancing act, and a classic example of how DUI sentencing often punishes the poor harder than the privileged. Now, Cervantes has a steady job, but imagine if he didn't. Would a mechanic or a line cook survive these fines without losing everything? This raises a bigger legal question. Is justice supposed to be equal or affordable only to those with steady income?
Okay. All right. And then the court is going to impose oversight fees at a rate of $35 per month. That puts us at $420. There will be a $100 pre-sentence investigation and substance abuse evaluation fee. Mr. Cervantes, when you were testing, or when you tested, did you test at the 36th District Court?
Yes, Your Honor.
Is that where you want to continue to test, or do you want to go to an outside agency?
No, 36th District is fine.
Okay, so then I'm going to add the testing into the fines, costs, and fees. So I'm going to order testing twice a month for the first 3 months. If there's no positive test, then it can be reduced to once a month. If you have positive tests in that time, then I'm going to consider sending you to sobriety court. So the total for the urinalysis is, oops. $90, I think. I may have added that wrong. That doesn't seem right. Oh, because I didn't add after that. 30 plus. Okay, no, so it should be 150. And then if you get discharged early, we will back out any use test. Also, the same for the supervision fees. If you get discharged early, then the supervision fees will only be $210. The total fines, costs, and fees for the 12-month probationary period are hold on. I don't like the way they do this new thing. Okay, 150, 210. Right. $1,280. If you plan to get discharged early, then your total is I think $1,025. I think I added that right. All right, then you also shall not use or possess any illegal substance. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. I'm going to say you cannot use any opiates. I don't know where he works. Like, I don't know his unit. And I said use or possess, but like if he work in drug task force or something, you know, he wouldn't get violated for that. You shall not consume alcohol in any form. You cannot drive without a valid driver's license. You must attend alcohol highway safety education level 1, the victim's impact panel, and watch the consequences video.
Here's a subtle but clever moment. The judge avoids ordering outpatient treatment for now. She's signaling restraint while also laying a trap. Fail another test, and rehab is mandatory. This shows us something important about probation. It's a tightrope. Courts try to encourage success, but build fail-safes if the defendant falls again. And then, in a move that will definitely stir debate, she considers dropping community service altogether, because being a cop might already count as serving the community. What do you think? Should his day job count as service after a DUI? Or does that send the wrong message about accountability?
I'm going to indicate that if you have any positive tests, I'm not going to order outpatient treatment at this time unless the people are requesting it. I was going to order, it is recommended by probation, but I was going to say if he had any more positive tests. Mr. Advisor, what's your pleasure?
I'm sorry, I missed that, Judge.
I said I wasn't going to order the outpatient treatment at this time, but I was going to say if he have another positive test, he must enroll in outpatient treatment, but it's recommended by probation. So I wanted to know what was your pleasure.
I would agree with the court. I think if he can maintain his sobriety without another positive test, he wouldn't need it. And if he
Okay.
tests positive, I have no objection to him then going to outpatient.
All right, so the court will indicate that outpatient treatment if positive. And then court is going to order the driver's improvement program, and there's a recommendation for 5 days of community service. I'm going to reduce that community service. 5 days would be equivalent to 40 hours. I'm going to just reduce it to 20 hours of community service. And if he holds off on the community service and does very well with the other part of his probation and comes to the halfway point complete, then I may waive the community service because he, by the very nature of his job, gives community service. But I want to see how he does if beyond halfway point. Okay. All right, I believe that concludes my order. I am going to, the court will mail a copy of this order to the address that's listed on the pre-sentence report. I won't say even the street. And then the phone number also that's listed on the pre-sentence report. That's where probation will contact you.
So here's the bottom line. Officer Cervantes walked out with a year of probation, a $1,000 bill, and a serious warning from Judge Bryant. He owned his mistake, showed remorse, but also violated bond with alcohol in his system, a huge red flag. The judge extended grace, but made sure everyone knew no more second chances. This case gives us a powerful glimpse into how the justice system treats those who enforce the law, and it sparks a bigger conversation. Is equal justice possible when the defendant wears a badge? Or does their position buy them leniency? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got plenty more where this came from.